Welcome back. In this lecture, we're going to talk about the growth and development of international law. Where did international law come from? How are we going to define international law for the purpose of this class? Now, we asked this question last time. What is international law? Now, there is a traditional definition, which is to say international law is the law, the body of law, the system of rules that regulates interaction between states. And whenever we talk about states in this course, we are talking about countries, nations, nation states, that concept. Nothing to do with the political subdivisions that we have here in the United States of America. These are true sovereign states. Now, since the end of World War II, the idea, the concept of international law has expanded beyond this traditional definition, and that's what we'll be talking about today. So in this lecture, we're going to look at the growth and development of international public law. I said traditionally international law is that law that regulates interaction between the states. Since the end of World War II, however, the notion of international law has expanded. It is no longer simply the body of laws that regulate interactions between states, but it also includes interactions between international organizations and states. International organizations like the United Nations, like the European Union, like the North Atlantic Treaty Organization, like the World Trade Organization. So that body of law is also called international law. And again, since the end of World War II, international law can include interactions between the states and sometimes their individual citizens. And so we'll be talking about that as well as when we talk about the expansion, the growth of international law. Now, it is no longer accurate to say that international law is simply a collection of rules. Instead, it's a rapidly developing complex of rules. And it also includes influential principles, practices, and assertions, which may not be binding on countries, but which countries follow out of a sense that that should be the law. And of course, it is coupled with these increasingly sophisticated structures and processes. So international law is a very broad concept. The range of subjects and actors directly concerned with international law has widened considerably. Moving beyond the questions of war and peace and diplomacy, which is what was the original basis for international law, but also now includes things like human rights, economic and trade issues, the law of outer space, and of course international organizations. And although international law is a legal order and not a body of ethical rules, it has been influenced by ethical principles and concerns. And this is particularly true in the sphere of human rights. And this is where we get to the idea that sometimes a state can violate international law in its treatment of its own citizens. So, international law can even reach the interactions between a state and the citizens of that state. What are the different philosophical bases for international law? Where did the idea of international law come from? Well, international law derives from two foundational bases. And we start with this idea that all law, for it to exist, must rest on some authority, meaning there has to be a basis for the law. And when it comes to international law, we derive international law from two foundational bases. And we start with what's called the natural law. international law can be based on natural law principles. International law can also be based on positive law principles. And we're going to talk a bit more about what each of those mean. But the idea is that our law is going to rest on some authority, whether that is the authority granted by nature or by a deity, or whether it's the law granted by sovereign states. So let's start with this idea of what is the natural law. Natural law, which you may also see called the law of nature, is an objective norm or set of objective norms governing human behaviors, similar to the positive laws of a human ruler, but binding on all people alike, and usually understood as involving a superhuman legislator. And what we're talking about here is the idea that there are some laws that are fixed in nature, that there are some behaviors that are wrong or are right without regard to what the law of a state would be. So, some of you may be familiar with the movies about the purge. That purge, it's a concept that one night a year, all crime is legal. Everything you do is legal. So, murder, robbery, theft, all legal. Now, when we look at this from a natural law perspective, we say it is true that one should not kill someone else regardless of what the legislature has said is possible. So, killing someone is wrong regardless of what the law says, whatever the state's rules are, whatever the statutes are, that it's just as bad to kill someone during a time of the purge as it is when it's not the time of the purge. So natural law is this idea that there are laws in nature that exist that are true no matter what the laws of a country may be. Now I say a superhuman legislator, or the author of this quote says that. What that really means is oftentimes it's associated with a deity, God. God has said these things are true, and therefore these principles apply to everyone, regardless of whether the state, the legislature, has said something different. Now, I always like to point out, when you look at what is an example of a natural law idea, you look to the United States Declaration of Independence. Because what does it say? It says, all men are created equal, and they are all endowed by their Creator with certain inalienable rights. Now, you probably never thought about what does inalienable mean, but alienation is a legal term, which is to say, when you alienate a piece of property, you transfer it from one person to another. And so when we use this phrase inalienable, or when Thomas Jefferson used the phrase, he meant, yes, these are rights that the government cannot take away from you, but they are also rights that you cannot give up voluntarily, because God has given you these rights. And so you have these rights regardless of what the law of the state is. So that's what natural law is. In the concept of international law, those principles, that idea that there are certain things in place that may be connected to God, maybe not, because the natural law doesn't necessarily have to be connected to a deity. We could also say, let's look at logic. Does it make sense? Is this possible? And one could say that we can derive these laws of nature simply by observing nature, by observing people. And we know that if we have a system where one person can kill another person or take their property, then that's bad. That's bad for all of society. And so this law must be found in nature that you should not kill another person. And so what the early philosophers did was they took this idea of natural law and they said there must be principles in place that guide interactions between states in the same way as there are principles in place that guide interactions between people. So natural law has some defining principles, and these were set out primarily by a Dutch philosopher named Hugo Grotius, who lived in the 1600s, and he articulated the foundational principles for international law. Now, Grotius did not subscribe to the idea that natural law came from God. Instead, he believed that the natural law came from an essential universal reason that all men shared. Now, one of the aspects of international law that Grotius is well known for is this idea of freedom of the seas, meaning if two ships are in international waters, they each have an equal right to be there. And this idea that freedom of the seas, that the sea, the ocean, is not something that is subject to political control in the way that land is, well, that was quite a unique idea. And it was embraced in large part by these Northern European powers that had started to explore and colonize and trade around the world. And this idea that this is a principle, the idea that people that travel on international waters without fear of piracy or another larger, more powerful country taking your ship, this had a lot of appeal. And so freedom of the seas is a concept that derives from natural law principles. So Grotius had other ideas as well. Grotius argued that law was not imposed from above, but again could be derived from principles. That these principles would allow for countries to exist and to interact with one another. And the first axiom often attributed to Grotius is the idea that promises must be kept. There's a Latin phrase, which we'll talk about several times later, called pacta sunt servanda. And what it means is that if you give a promise, you should keep the promise. And again, this is a natural law principle. We see it reflected in our statutes about breach of contract, and if you make a contract, you have to follow through with a contract. But one could argue that this is based on the idea, the broader idea, that if you give a promise, you should keep that promise. Now, the second foundational principle that Grotius stressed was the idea that harming another person requires restitution. When you get in a car wreck and it's the other person's fault, you can sue that person for your property damage, for the damage to your vehicle, but also for the damage to you. And this is based on the idea that if one party causes harm to another party, then that second party is able to gather restitution, compensation for that harm. And so when we talk about international law rests on principles like these, that if you give a promise, you must keep it. And if you harm someone, you should make good for that harm. So these two principles, we will see it reflected in other aspects of international law.